Hello everyone, welcome to Conquer Learning and welcome to today's video. Today we are going to study the Industrial Dispute Act 1947, which is one of the important act with exam point of view. So the Industrial Dispute Act 1947 is a lengthy legislation, so we would be studying in different parts, part 1, part 2, part 3 and part 4, right from evolution of Industrial Dispute Act till the subsequent amendment. So now let's start today's video where we are going to study the evolution and the important definitions of the Industrial Dispute Act. Before we move to the law or evolution we study before that, let's understand the meaning of the industrial dispute. Now, what do you mean by dispute? Dispute is any kind of indifference. Dispute is any kind of grievance. Dispute is any kind of dissatisfaction which employee is having with an employer who are the part of the industry. Now, this dissatisfaction is related to their terms and conditions of the employment and the terms and conditions of the unemployment. Now, what is employment terms and conditions? Like your hiring, your recruitment, your transfer, your promotion, and so on. And some other working conditions, it may be related to your wages, your salary, your safety measures, your working hours, and so on. And what are the terms of unemployment? Like your dismiss, discharge, termination. So if any person is dismissed, discharged, or terminated in a wrong way, it creates a indifference, it creates a dissatisfaction, it creates a dispute between employee and employer. So when this employee and employer are present in the industry and they have the indifference related to the terms of employment and terms of unemployment, this is called as an industrial dispute. Now, why this industrial dispute should be resolved? Because one, if this industrial disputes are for very long time in the industry, this may result in the strikes, lockout, picketing, gherao, and so on, which are not good for the industry as well as for the economy of the country. It would always have the condition of the strife, unhealthy employee and employment relation. So in order to maintain the harmony between employee and employer, and in order to maintain a healthy relationship between employee and employer in such a way that it leads to the achievement of the organizational goals as well as the growth of the country's economy, industrial dispute must be resolved. And for this purpose, the Industrial Disputes Act came into the existence. If we go back to the 19th century, when the industries were growing in the country India, there were number of the disputes which were happening between employee and employer. So government felt that it is very important to resolve the dispute, because if they are not resolved, it is going to affect the economy. So now the Industrial Dispute Act came into the existence in 1860 for the first time, which provided different preventive and settlement measures for the dispute. So let's now move to the evolution. How Industrial Dispute Act 1947 is in the form as it is existing, how it evaluated from 1860 to 1947. So the first law which was taking care of the settlement of the industrial dispute was the Employers and the Workmen Dispute Act 1860. This was the first legislative measure related to the industrial dispute. What was the provision? So the act empowered the magistrate to resolve the disputes related to the wages of the workmen, especially for those who are working in the railway, canals, and other public works. Other than this, it made the breach of contract, means if employee or employer are breaking the contract, it considered it as a criminal offense. So these were the two important provisions given by first legislative measure of industrial dispute. But later this act was repealed in 1932 and it was not that used. Then came very important Indian Trade Dispute Act 1929. This law basically came into the existence for the 5 years, a trial period of 5 years, which was later on extended. We will be coming to that. So now what were the provisions given by 1929? It provided or it empowered the central and the provisional government is your state government, to establish the court of inquiry and your board of conciliation. Now these are, board of conciliation is the settlement machinery, court of inquiry is your fact finding. Now here there are the members as well as the chairman who try to find out the fact or the reasons why dispute has occurred, and they submit their reports within 6 months to the appropriate government. So they are only the fact finding, whereas the board of conciliation is a board which consists of the chairman and the equal representatives of employee and employer, who tries to settle the dispute between the employee and employer in a friendly way by their agreement. So they comes with on the settlement. So central and the provisional government, court of inquiry and board of conciliation were given, they were given the power to form them for a investigating, settling the trade dispute. Second important provision, they rendered the lightning strike. Now what do you mean by lightning strike? When you go on the strike without the consent of trade union, without giving the notice to the employer, all of sudden अचानक से बिना किसी information के you are going on the strike, that is called as lightning strike. So this particular legislation considered the lightning strikes in the public utility concerns as a punishable offense. Next important thing was, no worker in the public utility services was to go on strike in breach of contract. So no contract should be broken up and the strike, people should go on the strike. Second important thing, that if the employee is going on the strike, the employees has to give the notice to the employer regarding the strike within 1 month before the striking and not less than 14 days notice in writing. So means if I am on 1st of Jan giving a notice, so till 14th of January, I am not supposed to go on the strike. So this 14 days, I am supposed to give the time period to the employer. And whenever I am going, suppose I am going on 21st. So within 1 month of this, 1 month from this, I have to notify the employer. Similarly, if the employer is doing the lockout, so employees goes on strike, employer does the lockout. So employer goes on lockout, he declares the lockout, he has to first notify the employees within 1 month before such lockout, and the notice which should not be less than 14 days. So these are the first two important legislations that evolved one by one. Then came Indian Trade Dispute Amendment Act 1932. Now what happened in 1929, there was the Board of Conciliation and Court of Inquiry. This was your settlement machinery, this was your fact finding. Now the members of this Board of Conciliation and your Court of Inquiry, if they disclosed any information by willful, willingly or unwillingly, the prosecution was done against them, they were punished. So there was no such protection provided in 1929 to the members of Board of Conciliation or Court of Inquiry. This was provided in 1932. So 1932 amendment provided the protection to the members of Court of Inquiry and Board of Conciliation, and they were given the prosecution or punished only, they were liable to the prosecution only in case of willful disclosure. जानबूझ के अगर डिस्क्लोज किया है इंफॉर्मेशन तो ही पनिशमेंट मिलेगी, अदरवाइज नहीं. सो दिस इज द सेम थिंग विच आई हैव एक्सप्लेन्ड यू. देन ट्रेड डिस्प्यूट एक्ट एक्सटेंडिंग एक्ट 1934. As I said you, 1929 law was experimental for 5 years, which was going to expire on 7 May 1934. 5 साल के लिए किया था, वो expire होने वाला था. So with a view of making the act permanent, the Trade Dispute Act 1934 came into the existence. So it now made the Dispute Act permanent in nature. Next very important legislation is Trade Dispute Amendment Act 1938. Please remember, this was on the recommendations of the Royal Commission on the Labour. This was the direct outcome of recommendation made by the Royal Commission on Labour. What were the provisions here? Here the conciliation officers came into the existence. So the act empowered the central and the provisional, that is the state government, to appoint conciliation officers for mediating and promoting the settlement of industrial dispute. It enlarged the definition of public utility services. What do you mean by public utility services? Those industries, those establishments which are working in the interest of the public, like your water, your transport, your electricity, and so on. So this definition was more enlarged, and it covered power plants, tramway, water transport used for carrying passenger. Beside this, the regarding illegal strikes and lockouts, this were made less restrictive, and definition of trade dispute was enlarged. So these are the evolution, or this is how the Trade Dispute Act evolved one by one. Now, very important rule of a defense rule of India, which is number of the time the questions are asked in from this particular rule, because this is rule number 81A of the Defense of India rules, is the rule which is even today used in our Industrial Dispute Act 1947. Now, what are the rules? So, when did this rule 81A of Defense of India rule came into the existence? So, it was during the Second World War period, when government adopted certain emergency measure to prevent the war efforts from being impeded by the industrial strife. So they wanted to reduce the effect of the war, or did not wanted to extend. So they started applying certain restrictions on the industries. What were they? So then the rule 81A, which was added to the Defense of India rules in January 1942. Please remember, this is also a PYQ. Then when was the rule 81A added to the Defense of India rules? It was January 1942, which empowered the government. So these are the important provisions which are still used in our Industrial Dispute Act, to prohibit the strikes or lockout by general or the special order in connection with any trade dispute unless a reasonable notice was given. So the government can prohibit the strikes and lockout by the general or special order if the notice is not given regarding those strikes or lockout. To refer any dispute to conciliation or adjudication. Conciliation is a mediation where third party tries to resolve or settle the dispute by friendly way. Adjudication is where the third party, usually the presiding officer of labor court, industrial tribunal, national tribunal, they give the award which is binding on employee and employer. We will study this in the detail in coming slides. So this empowered the government. So suppose there is a dispute between the employee and employer, and it is not getting resolved by themselves. So government has the power to interfere and give this dispute or refer this dispute to the conciliation और दी एजुकेशन. आपस में सहमति नहीं हो पा रही, आपस में सॉल्व नहीं हो रहा है, तो आप कंसिलिएशन के लिए जा सकते हो. ये पावर किसके पास थी? गवर्नमेंट रेफर करते थे. It required the employers to observe specified terms and conditions. Employer भी terms and conditions follow करेंगे. To enforce the decisions of adjudicators. Adjudicators जो लोग decisions देते थे, award देते थे, जैसे प्रिसाइडिंग ऑफिसर इन लेबर कोर्ट, इंडस्ट्रियल ट्रिब्यूनल, नेशनल ट्रिब्यूनल, it was enforcing means it became binding. So in binding means they cannot, अब आपको एम्प्लॉय और एम्प्लॉयर को एक बार बाइंडिंग होने का मतलब मानना ही पड़ेगा, whether you agree or not, you have to follow it. So in pursuance of this law, the government of India promulgated an order in 1952 prohibiting the strikes and lockout without the notice of 14 days. So this became compulsory after the 81A rules, that you have to give at least 14 days notice, previous notice, and during the pendency of conciliation or adjudication proceeding. So during this process, जब आपका conciliation के लिए या adjudication के लिए आपका matter, आपका dispute वहां पे pending है, तब आप strikes पे नहीं जा सकते. The rule remained in force in 1946, but the period of its operation was extended under the Emergency Power Continuous Ordinance 1946. Most of the provisions of the rule were incorporated in Industrial Dispute Act 1947, which with the subsequent amendment is still in the force in our country. So hence this particular rule become very important from exam point of view. These all provisions are still used in our Industrial Dispute Act 1947. So this was the evolution. What are the subsequent amendment? We will be studying them once we complete the complete legislation, because then only you would be able to understand the amendment which has happened in the Industrial Dispute Act 1947. Now let's move to our most important, the Industrial Dispute Act 1947. This particular act has the objectives of maintaining the harmony in the organization, maintaining the healthy relationship. It provides the settlement and the preventive machineries for resolving the dispute between employee and employer. It provides the negotiation or conciliation methods for solving and preventing the industrial dispute. So these all are the objective of Industrial Dispute Act 1947. Let's start with the definition. So section number 2A defines the appropriate government. Central government would be appropriate government if it is a DOC, Labour Board, Industrial Finance Corporation of India, ESIC, the Board of Trustee, Indian Airlines, Air India Oil and Natural Gas. State government, any other state public sector undertaking, there the appropriate government would be the state government. I have number of the times explained you what do you mean by appropriate government. So central government would be appropriate government in this cases. Other than this, if it is a state public sector undertaking, state government would be the appropriate government. Next, very important definition is award. Now, what is award? See, adjudication process is the process when employee and the employer are having the dispute. इन दोनों के बीच में dispute है. They are not able to resolve. अपने आप resolve नहीं कर पा रहे हैं, तो वो कंसिलिएशन के लिए जाता है. थर्ड पार्टी जो फ्रेंडली वे में इनका सेटलमेंट करवाता है, वहां पे भी नहीं होता है, तो फाइनली वो एजुडिकेशन के लिए जाते हैं, वेयर दी presiding officer is appointed for labor court, industrial tribunal, national tribunal. सो इंडस्ट्रियल ट्रिब्यूनल एंड नेशनल ट्रिब्यूनल में जो प्रिसाइडिंग ऑफिसर होते हैं, ये इन दोनों के कंडीशंस को चेक करते हैं और लास्ट में फाइनल देते हैं अवार्ड, अपना फैसला सुनाते हैं जो एम्प्लॉय और एम्प्लॉयर के ऊपर बाइंडिंग होता है. सो दिस a final interim or a final determination of any industrial dispute given by the labor court, industrial tribunal or national industrial tribunal is called as the award. Second, section number 2C defines board. So board of conciliation, which is constituted under this act, in the short form it would be called as the board. Who is the conciliation officer? The conciliation officer, one who is appointed in this act. What is conciliation proceedings? Proceeding held by the conciliation officer or the conciliation board. इनके पास में whatever proceedings would be pending with them, they would be called as the conciliation proceeding. One for conciliation board and conciliation officer. We'll study them in detail, what is all of them. Next important definition is section 2EE, controlled industry. Now what do you mean by controlled industry? Those industry which has been declared by the central act to work in the public interest, like your water, transport, they all are called as controlled industry because they are working only in the public interest. So see, this is the question. Award under the Trade Dispute Act 1947 is not an interim determination of labor court, not an arbitration award under section 10A, not a final determination of labor court, not a final determination of arbitration award under section 10A. All statements are true. Option 1. A, B and D are true. B is true. All statements are false. So the correct answer here is all statements are false, because award means what? A final interim, a final determination in all the cases. So these are the type of the question where the award or such definitions can be framed into the question. Next, very important definition is section 2G defines employer. Now, who is employer who would be responsible for maintaining good relationship? So, if it is an industry under the central or the state government, the head of department or the person who is appointed for the controlling the affairs or the head of department would be called as an employer. If it is the local authority, the chief executive officer, one who is appointed as CEO, would be an employer. Next, what is now industry? We say the Industrial Dispute Act. What is industry? What all is covered in the industry? Any business undertaking. So any business undertaking, trade, where manufacturing or calling of the employers means service, including any calling, service, employment, handicraft, or industrial occupation or evocation of the workers contract basis पे, includes municipality, educational institute run by municipal cooperation. So only those municipalities and educational institutions which are run by municipal cooperation, these all are called as industry. It does not include hospital run by the government and club. They are not the industry. They are not the definitions. Please remember, the question may be framed here that what are industries, what are not industries. Then comes your section number 2K, industrial dispute. Now, what is industrial dispute? Very important, even the sections may be asked. So, any dispute or a difference between the employer and employer, between two employers, between employer and the workmen, between workmen and the workmen, दो employer के बीच में, दो एक employer और workmen के बीच में, or the workmen and workmen. So the dispute between any one of them connected to the employment or non-employment. I explained you in the starting, employment is your hiring, recruitment, transfer, promotion. Non-employment, discharge, dismiss, termination, or the terms of employment or condition of employment like your wages, working hours, safety measures, and so on. So difference related to any of this matter will be called as an industrial dispute. Now, what do you mean by layoff? You must have heard during the COVID-19 period, number of the employees are being laid off. Every day there has been news that this person are laid off. Now, what do you mean by layoff? कब करते हैं layoff? So, this layoff is done by the employer. What happened? In COVID-19, every industry was closed, the business was down. As a result, what? Since the business was down, there was no money left with the employer. There was no business, there was no demand in the market. As a result, the employer became incapable to hire all number of the people. If I'm not having the money, if I'm not having the business, काम ही नहीं है, तो क्यों रखना एम्प्लॉयज को. सो एट दैट पॉइंट ऑफ द टाइम व्हेन ही इज फेलिंग, व्हेन ही इज इनेबल, he is not capable enough to hire or keep all the employees due to what? Due to the shortage of the material, due to the shortage of power, due to the accumulation of stock, or due to the breakdown of machinery, natural calamities, and so on. This incapacity of the employer to hire any number of the employees is called as layoff. मेरी अगर कंपनी है, बिजनेस नहीं चल रहा है, तो मेरे पास में पैसा नहीं है, राइट, एंड बिजनेस नहीं चल रहा है, शॉर्टेज है किसी भी चीज की, तो आई कैन नॉट कीप द एम्प्लॉयज विथ मी, सो आई वुड रिमूव देम, राइट. सो आई वुड ले ऑफ के इतने टाइम इतना. नाउ ले ऑफ इज नॉट रिमूविंग. ले ऑफ इज लाइक यू आर आस्किंग देम टू सिट एट होम. दे आर पेड फॉर द ले ऑफ, रिटेंच उनको कंपनसेशन मिलता है. दे ले ऑफ पीपल कैन बी कॉल्ड बैक. Okay, those who are laid off, they can be called back. So the failure, refusal, or inability of the employer on account of shortage of coal, power, or raw materials, or the accumulation of stocks or breakdown of machinery, or natural calamity, or for any other connected reason, to give the employment to workmen whose name is borne in muster roll. Muster roll in the sense whose name is register. एक रजिस्टर होती है, एक एम्प्लॉयमेंट की लिस्ट होती है, उसमें जिस भी एम्प्लॉय का नाम रजिस्टर्ड है, उन एम्प्लॉयज को एम्प्लॉयमेंट नहीं दे पा रहे हैं. of his industrial establishment who has been not retrenched but retrench nahi kiya. So now what do you mean by retrench? We will be studying there. Section number 2KK, we said layoff. We understood it. I hope you have understood it. This is done by the employer when he is not capable enough to give the employment. Lockout. This is also you can say a step taken by the employer. This is against illegal strike, or it is against when the employer wants the employee to work according to them. नहीं कर रहे ना आप हमारी तरह हमारे हिसाब से काम, तो हम बंद कर रहे हैं. So it is a temporary closing. Temporary basis पे when you close the place of employment, maybe one plant, maybe half of this. So the temporary closing of the place of employment, the key word is temporary closing. The temporary closing of the place of employment or the suspension of work, or by refusal by the employer to continue to employ any number of the person employed by him. So this is usually done if the employees has went on illegal strike, if the employer wants their employee to work on their terms and conditions. So वो lockout करते हैं. It is for the temporary period. Next, very important definition, section 2N defines public utility services. So as explained you, public utility services, those who are working, which industries which work in the interest of the public. So any railway, any transport for carriage of passenger or goods or by air, any services or in connection with work or any major port or dock, any section of industrial establishment on safety or establishment, postal, telegraph or telephone services, any industry which supplied power, light or water, any system of public conservancy and sanitation. So this is mentioned in the first schedule. Under the first schedule, the public utility services are mentioned. All those list of the industries or services which are mentioned in the first schedule are called as public utility services. Now, very important definition is section 200, retrenchment. What do you mean by retrenchment? So, it is the termination of the employment, यानी employment खत्म. अब आप नौकरी पे नहीं आ सकते. So means the termination by the employer of the service of the workman for any reason whatsoever otherwise than. So other than all this reason, इनके अलावा, other than all this reason, any other reason, because of any other reason the person is being terminated from his service, it is called as retrenchment. So voluntary retirement of the VRS is not the retrenchment. Retirement of the worker on reaching the age of superannuation. Now what do you mean by superannuation? There are two terminologies, as we call it as retirement and superannuation. Retirement is official age of 58 years or the 60 years, whichever is the official age of retirement, that is the retirement. Superannuation is like you are working in public utility services and you have signed a contract with this public utility or public sector unit that till the age of 54 years or 55 years or 50 years of age, whatever, it may be any age. So whatever you have signed a contract that till the age of 50 years you would be working with the organization. So as soon as you attain the age of 50 years, you are going to vacate that position. आप अब जाओगे because 50 years तक का ही contract था. So this age when you vacate that particular position is called as superannuation age. So this is also not the retrenchment. Termination of the service as a result of non-renewal or non-expiry of contract. Your contract was there, it has been not renewed, so it is not retrenchment. Your expired, the contract has expired, not retrenchment. Termination due to continuous ill health. You have been not well since very long period of the time and that's why you were asked to leave the organization. This is also not the retrenchment. So any other reasons other than this is called as the retrenchment. Next comes section 2P defines the settlement. The settlement or the agreement, basically the agreement which is arrived during the conciliation process, which may be by conciliation officer या board of conciliation. So this is the mediation where the third party tries to resolve the dispute between employee and employer and they bring them into an agreement. So this agreement is signed by both of them, and it becomes a settlement. So what do you mean by settlement? A settlement arrived in the course of conciliation process includes written agreement signed by both the parties and the copy to be sent to the officer authorized in this behalf by the appropriate government and the conciliation officer, और उसकी रिपोर्ट अथॉरिटी के पास जाती है. Very important definition. What do you mean by strike? Strike कब होता है? So when the employees or the body of the person employed in industry, the body of person employees in industry means number of the people together. This cessation of the work, cessation, they are not doing the work. They have stopped doing the work, acting in combination, or a concerned refusal or a refusal under the common understanding of any number of the person who are or have been so employed to continue or accept the employment. So number of the people coming together in combination, they are refusing to work for the employer is called as the strike. Right? This words you need to remember. मना कर दिया कि हम नहीं काम करेंगे, हम बैठेंगे. So now this is the question, which of the following action does not qualify strike within the meaning of the section 2Q of Industrial Dispute Act 1947. So strike, pen down strike is tool down, जहां पे आप अपने tools रख देते हो, आप काम नहीं करते हो. So this is strike. Stay in is like where you stay in the office, you stay into the premises but you do not work. तो काम नहीं कर रहे हो, तो again a strike. Tool down similar to pen down. Go slow is like you work but you reduce the productivity. So if you were producing 1000 goods, now you are producing only 100 goods. So reducing the productivity is called as go slow. Slowly काम कर रहे हैं. So this is not the strike. Strike में क्या होता है? Completely काम बंद कर देते हैं. Go slow में there is the work but at the slower pace. Okay. Next, section number 2RA defines unfair labor practices. As given in the 5th schedule, all those practices which are done by the employee or employer, or all those practices which are mentioned in the 5th schedule are called as unfair labor practice. Now, what do you mean by unfair labor practice? Some actions, practices carried out with the bad faith and with the purpose to harm another. किसी की बुराई करने, किसी का रॉन्ग करने के लिए आप कोई एक्शन लेते हो, दैट इज अनफेयर लेबर प्रैक्टिसेस. देन we come to our section 2RR, wages. Very important definition. Why this wages need to be studied? Then when we give the compensation for the layoff, we give the compensation for retrenchment, we give the compensation for the closure, we give in layoff 50% of the wages. So ये जो wages हैं, इसमें क्या क्या calculate होगा? What would be calculated in this wages? So all remuneration being expressed in the terms of money payable in workmen in respect of employment. So any remuneration which is can be expressed in the terms of money, monetary form में express किया जा सकता है. Those which is payable to the workmen in respect of employment, it will include your DA, dearness allowance, value of house of accommodation. This is where the person is given the quarters and so on, the value of that. Supply of light, water, maintenance, concessional rate of food grains, this would be included. Any traveling concession, this will be included. Commission payable on the promotion sales, this will be included. Not included, bonus, contribution of PF and gratuity. It means what? So suppose the person is being laid off, I have to give the 50% of wages. So while calculating in this wage, whatever DA, suppose he is getting 1000 rupees as DA, the value of house of accommodation is 500, supply of light is 500, traveling concession is 1000, commission is 500. So I will total it all and give the 50% of it. But I won't include if there is any PF. So suppose PF contribution is 300 from employee and employer. So I won't be including that. It won't be included, right? So that is why we study the definition of wages. Workmen. Now, who is workman? Who can have the dispute with the employer? Any person employed in industry, including the apprentice. So apprentice, the people working in the apprenticeship also are called as workmen. They can also have the dispute to do any kind of manual, unskilled, skilled, technical, operational, clerical or supervisory work for hire or reward, whether the terms of employment be expressed or implied. Whether expressed or implied means whether they are written or oral. Includes any person who is dismissed, discharged or retrenched. So these people are also workmen because they would have the dispute. Connection with or the consequence of the dispute or dismissal, discharge or retrenchment has led to that dispute. But it does not include police, army, navy force, any employees of prison, managerial or administrative capacity, in supervisory capacity, working or earning more than 10,000 rupees. These are not called as workmen. This 10,000 was added by the amendment of 2010. So monthly 10,000 rupees who are working in supervisory capacity, they are receiving 10,000 rupees monthly. They are not the workmen. So this is the important definition of the workmen. Section number 2A, this is again very important definition which defines individual is deemed to be an industrial dispute. Usually what happened when the dispute is called to be an industrial dispute? When it is affecting large number of the people. But we have the individual disputes as well. एक अगर person का indifference है, it would be an individual dispute in case of what? If an employer dismisses, discharge or retrenches or terminate the individual, तो सबको तो नहीं करेगा, एक इंडिविजुअल को ही डिसमिस करता है. सो उसका हम उसको इंडस्ट्रियल डिस्प्यूट कहेंगे. Yes, it would be considered as industrial dispute. So any dispute or difference between the workman and his employer connected with or arising out of such discharge, dismissal, retrenchment or termination shall be deemed to be an industrial dispute. See, dismissal is your action taken against wrongdoing. So it is a kind of punishment. Discharge is just removal from the duty. Okay, dismissed is against the wrong thing as in punishment. So this is not the punishment, this is the punishment. So shall be deemed to be an industrial dispute, notwithstanding no other workman nor the union of the workmen is a party. So it's not important here that there should be complete group of the people getting affected. Even if one person is dismissed, discharged or retrenched wrongly, he would be considered to have a industrial dispute. Now, the application to the conciliation officer after the expiry of 45 days, workmen can go to the labor court or tribunal for adjudication. So this dispute, when they occur, they make an application to conciliation officer. Once this application completes the 45 days with the conciliation officer, after this 45 days, the workman can directly approach labor court or tribunal. The workman should make an application within the expiry of 3 years of dismissal, discharge, retrenchment and termination. And this application has to be made when from 3 years. 1st of Jan 2019 I was dismissed. So 2019, 20, 21, 22. So the expiry of 3 years. Before the expiry of 3 years, I can make an application. Very important definition. Fine. So this is the, here I'm going to end. All the definitions are completed. In next class, we would be starting our work committees, authorities under this act. So I hope you understood. Thank you so much for this session. We would be meeting in our next video. You have any doubts, you can ask me.